So he's not a good candidate for probation. I'm not giving him probation.
Well,
And
Judge,
does he not understand what no contact means? No contact means no contact. Charge where you're choking her. There was a protective order in place, and you were calling the complainant from the Bexar County Jail. Mr. Ross, in each cause number, did you review the application for deferred adjudication with your attorney? Did you understand it? And
He called her from jail 26 times after a judge told him no contact means no contact, and he still stood up in court and said he was entitled to walk free. This is the case of Z, Wilson Ray, a man with a documented history of violating protective orders, standing in front of Judge Stephanie Boyd in a Texas courtroom, while asking for mercy he'd already spent. 2 cause numbers, 2 separate timelines of abuse. One woman caught in the middle of both. She was 15 years old when she met him. They'd been together since they were kids. By the time this case landed in front of a judge, they'd built 15 years of history together and 3 children. 15 years is a long time to learn someone's patterns, long enough to know exactly how he'd come back. The first case assault, family violence, impeding her breath. That's the legal language for choking someone until they can't get air. Not a slap, not a shove, his hands on her throat, cutting off the one thing she needed to survive the moment. The second case, violating a protective order 2 or more times within 12 months. A 3rd-degree felony. Not because he forgot the order existed, because he picked up a jail phone and dialed her number anyway, December 6th, December 11th, December 15th.
I don't see the December 6th, December 11th.
What those dates are referring to, which I guess we could figure out how to put in these situations where those were days that the defendant called the victim from jail. So those would be reported to jail.
All right. So
and we've been provided with those, Judge.
I'm sorry?
We've been provided those.
Well, are you stipulating that, because he pled no contest, is there a stipulation that he made phone calls to the complainant from the jail on December 6, 2024 and December 11, 2024? And December 15, 2024, December 20th, 2024, and January 25th, 2025?
January 25th, comfortable. 5 separate dates the state tried to put on the record. Phone calls placed straight from the Bexar County Jail to the woman a judge had ordered him to stay away from. A protective order is supposed to be a wall. For him, it was a suggestion he ignored every time he had jail credit on his account. And here's where the system actually worked the way it's supposed to. Defense tried to get him deferred adjudication, a deal that, if completed, would leave him with no conviction at all. His attorney stood up and told the judge he was legally entitled to it because he had no prior convictions. Judge Boyd didn't let that sentence finish landing before she came back at her. What do you mean he's entitled to deferred adjudication? No statute, no legal basis, just an attorney asking the court for mercy and dressing it up as a right. Then came the part defense really didn't want in front of the judge, the dates. 5 calls alleged in the indictment. The defense tried to walk it back, claiming they only had a stipulation covering 1 date, not 5. They wanted the rest scratched, no proof, no consequence. Judge Boyd went line by line.
Okay, so where's the...
I think she downloaded it and put it on the disk to have as part of the stipulation.
Well, December 2nd was the date of offense. I was just trying to confirm that, Judge.
Well, so here's the thing. If he's not going to stipulate that what's in the indictment, the dates, then we can't proceed. I can't proceed on those dates. And if there's no additional information that's given to the court, then the court is going to find him not guilty of this because.
And Your Honor, if I may, Ashley Jones for the record, all that's required for the statute is 2 offenses within a 12-year period. The first offense is going to be December 5th, which is listed in the report, and then the second offense will be the January 25th date, which is in the report. So that would be 2 violations within a 12-month period, and we can scratch or amend the.
All right, so y'all want to admit. All right, so we're back on the record. Well, I don't even see the January 25th date in here.
It says January 23rd, yes.
Well, that's they have it listed as report time. I don't know if that's the report time when they made the police report or the report time for this offense. Wait, just one moment. Let me see. All right. You're correct. So that on or about date time is the time when they filed the report, but also the time when she's saying it happened. So the court will find there's sufficient evidence to find you guilty in 2025 CR 004086. The court will defer finding of guilt as you apply for deferred adjudication. And you're saying that you wish to waive PSI?
December 5th. She couldn't find December 6th in the paperwork. Couldn't find December 11th either. Well, she told both sides flat out, if nobody's going to stipulate to what's in the indictment, she can't proceed on dates that aren't backed up. Well, this is the moment most courtrooms let slide, not this one. The judge kept digging until she landed on 2 dates. She could actually hang a felony on December 5th and January 25th. 2 violations inside a 12-month window. That's all the statute requires. She found it, and the case moved forward on facts, not on what the defense hoped she'd forget to check.
On behalf of your client.
Your Honor, my client, he's 27 years old. He is not native to Texas. He's from Indianapolis, Indiana. I'm sorry? Chicago, Illinois. I apologize, but he, as mentioned before, he's 27 years old. The victim and him are obviously very familiar. They've been together since they were children. So I think since they were like 16 years old. Is that right? 16? 15. Since they were
All right, does he
15.
want to testify?
No, Judge. Let me just finish. I'm so sorry.
All right, so you can't get information from him, then turn back to the court to give whatever information he's given you if he's not going to testify.
Okay, I'll just
All
proceed.
right.
I'm sorry, Judge.
No problem.
And they do have 3 children together. And obviously they've had a myriad of things happen, I guess, in their lives, and they have both matured and progressed. And my client wishes to accept responsibility. He understands that the only way he's going to see his children, because that was another thing that we talked about, was that there will be a no contact order. That is something that obviously he's vehemently opposed because he does have 3 children. And so I did advise him that this would be part of the plea agreement, and if he wants to hire a lawyer and get some custody issues and orders in place so that they can go around that order, in order for him to be able to see his children, because obviously the state is not asking for a no contact order with the children. It would only be with the mother, the natural mother, which is the victim here. I have spoken to his father. I am not sure if yesterday he was on the Zoom and standby, and I mentioned him that he would at the same time today. And I don't know if he's in the waiting room or not, but notwithstanding, my client does want to go forward. His father obviously speaks very highly of him. Unfortunately, he did get arrested in February 27th, which is when he got booked for the last time. So he's been obviously in custody for almost going 3 months now. He's got health issues at the jail, Your Honor. He's got psoriasis.
Defense told the court he was 27, not from Texas, Chicago, Illinois, 3 kids with the victim. A no contact order he was vehemently opposed to. Health issues in the jail. Psoriasis, 110 pounds lost in 3 months, a man trying to enlist in the army, a recruiter on standby. The argument, give him deferred. Let him stay clean on paper, let him ship out. Then the court learned something the defense buried in the middle of the speech. There was already a prior jury trial in Indianapolis in 2019, same victim, where he was found not guilty, and a protective order filed against him in February 2025. The same year, that got dropped only because the victim left the state. A pattern isn't an accusation. It's a paper trail.
I do want to state that, we took a little bit of time going over the criminal history. There was a jury trial that happened in December of 2019 in Indianapolis, Indiana. So that's why I'm sorry, I was confused about the city, that there was an actual jury trial and he was adjudicated not guilty with the same victim. There was also, I want the court to take judicial notice of clause number 2025 CI 04103. There was an application for protective order that was made by the victim February 25th, 2025, and it was non-suited in April 17th of 2025. My understanding, and the prosecutor wouldn't really talk to me too much with respects to the protective order. Ms. Colon, but she did confirm that it was non-suited due to her leaving the state. So the victim,
Due to what?
the witness leaving the state.
And this paper trail went back at least 6 years with the same woman's name on it. Judge Boyd laid out exactly why probation wasn't on the table. Well, there was a protective order in place, and you were calling the complainant from the Bexar County Jail. Does he not understand what no contact means? No contact means no contact.
No, he's not. And let me just tell you why. Based upon everything that I've seen, there was a protective order in place, and you were calling the complainant from the Bexar County Jail. I mean, does he not understand what no contact means? No contact means no contact. And then we have this charge where you're choking her. So he's not a good candidate for probation. I'm not giving him probation.
4 years in prison. Each cause number. Running concurrently, a oner's 500 fine. Credit for time served. No contact with the complainant. No contact with minors. An affirmative finding of family violence, meaning he can't legally own a weapon, can't be the primary custodial parent for the children he says he wants to fight for.
In each cause number, I'm finding him guilty. I'm going to sentence him to 4 years in the prison, give him credit for any time served. There's a $1,500 fine, time and money to run concurrent. The cases are to run concurrently. There's to be no contact with the complainant and no contact with minors. And cause number ending and cause number 2025 CR 003533. There's an affirmative finding of family violence. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal in each?
He tried to speak after sentencing. The court told him his attorney had already advised against it, and the sentence had been passed. If he wanted to say something, that's what motions are for. But this wasn't even the only case in front of Judge Boyd that day. Second matter, a second defendant, going by Wilson Ray Jenner, connected to the same pattern of behavior, this time facing a kidnapping charge alongside another repeat protective order violation. The victim this time, Jennifer Tubar, his wife of over a decade, she took the stand.
State.
Ms. Tovar, you are the victim in this case against Mr. Zaragoza. Correct?
Yes, sir.
And you are aware that he has applied for deferred adjudication with probation.
I am.
And are you in what are your feelings if the defendant were to be granted probation?
Objection, Your Honor.
And what's your objections?
He's telling you what effect your decision will have on her. And we don't want her influencing.
All right, that'll be sustained.
Do you want the defendant to be released on probation?
Objection, Your Honor. It's the same thing.
Sustained.
Sworn in, stated her name for the record loud enough for the court reporter to catch. She told the court she had a protective order against him right now, in that moment. The defense tried to stop her from saying whether it actually kept her safe. Objection sustained once. Overruled the second time when the question came back sharper. Her answer.
And Ms. Tovar, you currently have a protective order against the defendant?
I do.
And do you feel that is sufficient to keep you safe?
No.
And why is that?
Objection, Your Honor.
What is your objection?
She's commenting on what your decision will ultimately do to affect her and her children.
All right, that'll be overruled. You can answer the question.
No, I don't think so. It didn't in the first place. It didn't. Ray was still coming around and still calling.
And while these cases were pending, you did have a no contact order against the defendant, correct?
Right. But I thought I was told that to let him talk to the kids. So even though we have a no contact order, that's why I was taking calls so that he could talk to the kids. I didn't want anybody to say that I wasn't allowing it.
Well, it didn't keep her safe in the first place. He kept coming around. He kept calling. He used collect calls from custody because he didn't have money on the books for anything else. And for a while, she accepted them because she didn't want anyone saying she kept him from his kids. A no contact order doesn't come with an asterisk for child visitation. But that's the bind these women get put in. Protect yourself or protect your ability to co-parent without a paper trail working against you. Then he took the stand himself. Said he wanted to apologize. said this was the longest stretch he'd ever spent in jail, said he'd written the court a letter about his feelings.
Yes, I feel that given probation, I could complete probation. As you know, I haven't been in trouble before, Your Honor. This is the longest I've been in jail. I feel that I've made a mistake. And if you read the current note I wrote to you, Your Honor, it describes more of my feelings. I want to apologize to the court, and I want to apologize to my wife, who we've been together 11 years, 10 years. Been with the family 15 years. All I know is my family, Your Honor. And I'm asking for your leniency and your mercy, Your Honor, for probation.
He admitted to violating the no contact order, but reframed it. She came to my home and moved in with me because she had no place to live.
That is wrong. She came to my home and moved in with me because she had no place to live. I wasn't going to leave my wife and my kids out on the street.
I wasn't going to leave my wife and my kids out on the street. Asked directly if he tied Jennifer Tobar up with duct tape during the kidnapping incident. His answer, no, that is incorrect.
In this kidnapping case, you did tie up Miss Tovar with duct tape, is that correct?
No, that is incorrect.
No evidence offered to back that denial. No witnesses called to support it. Just a flat no delivered under oath, comfortable with the prosecutor moving straight past it to the next question. Because some answers don't need to be argued with. They just need to be on the record. He claimed he'd never been in trouble before this. The state pulled up a prior case out of a different county. Another protective order violation, same pattern, whole different jurisdiction. His excuse, he was in custody and couldn't comply with a check in requirement during that case either. Custody.
And you said you've never been in trouble before, but you did have a case out of Atascosa County, Texas, for a violation of bond or protective order in that county as well. Is that correct?
That was for phone calls for talking to my children, which I had the right to do. And if you check the records, it says for electronic communication, I was allowed to talk to my kids.
And you did abscond during that case on February 9th of 2023. Is that correct?
Is that?
You just didn't do anything and you failed to report.
The explanation for everything and the explanation for nothing. The state argued against probation directly, a man who violated court orders repeatedly, regardless of what circumstances he claimed justified it, was still a man who chose contact every single time he had the option not to. The judge pushed back on the prosecutor too, asked if the victim moving in with him wasn't at least mitigating given the financial hardship. Fair question, but the answer mattered more. It doesn't matter who initiated the contact. The order existed to make him say no.
Yes, Your Honor. We're opposed to the defendant being granted probation. While you heard from the victim that she does not feel protected just by the no contact order, and that the fact that he was charged with a repeat violation of court order bond condition twice, which are being taken into consideration in this offense, Your Honor, shows that the defendant, whatever the allegations were, completely disregarded the court's order, and telling him that he's not supposed to have any contact with the complainant.
But what about his saying that she came to live with him?
Your Honor, regardless of what the allegations are, if he knew that he had these charges pending.
No, I understand that, but isn't that mitigating the fact that she chose to go and live with him? Now, I understand financially there are issues, but a no contact order, of course, it's a document, it's on paper, and the defendant knows they're not to have contact with them. But what about his saying that he had a choice? Either his children were going to be on the street with her, or either she was going to come and live with him. But it doesn't appear in that situation, if it's truthful, he didn't go and have her come live with him. She decided to go live with him.
That is correct, Your Honor. And while it may be mitigating there, knowing that he did have that no contact order, there are other options for Mr. Tovar to be able to take care of his children without having contact with the complainant. He could have taken the children while Ms. Tovar went to go find another living arrangement.
Do you know she wanted him to take the children and leave without her children?
That I'm not aware of, Your Honor.
Okay.
But given that and given the allegations in this case, Your Honor, we don't feel that I'm sorry.